Under either state law or federal law. The model law in this area is the FAA, the Federal Arbitration Act. If you'll just glance through these four grounds with me, you will see how difficult it is to upset or vacate an arbitrator's ruling. You'd have to show that the ruling was procured by corruption, for point one, or that the arbitrator demonstrated, quote, evident partiality. It's not just partiality, it has to be evident. Or three, guilty of misconduct, but look how misconduct is defined so narrowly, in refusing to postpone the hearing. Well, the long story short is, that is a rare issue in arbitration. A, because people don't ask for a postponement all that often, and when they do, their request is granted. And even if it's not granted, does that rise to the level of misconduct? So these three grounds are exceedingly narrow. The fourth ground is not quite so narrow. The arbitrators exceeded their powers. The contract will specify what their powers are. The issue will specify what their power is. And so if the arbitrator acts outside the bounds of that, then the award can be vacated or overturned. Now, several people, there are state arbitration acts that essentially repeat the federal law. The most important thing to note from this slide is there are some emerging differences. More and more state legislatures are expanding the grounds for reviewing an arbitration award. This comes principally from advocacy groups for women, for the poor and disadvantaged, who say mandatory arbitration really is a subversion of justice, and unless judges can get into the heart of the case and look at the merits, this is not a good thing, and it's not a just outcome. So you do have some states that are tinkering at the margins with review of arbitration awards. All right, we're on this second path. The first path was campaign laws, and the next path is employment arbitration. It turns out that many of the concerns about employment arbitration have not been realized. And I'll tell you from a personal perspective, as a student of this system, I wrote in the 1990s that this is a horrific idea. And empirical research has shown otherwise. So I'm picking somebody else's research, Michael Delicat and Morris Kleiner. But they examined a cross-section of arbitration awards that were taken to court. And this particular study involved arbitration rulings in the securities industry. These were employment cases. They were not investment cases or things of that nature. They were in the Southern District of New York, a high-profile court, and they found that employees prevailed about 34% of the time in court versus 46% of the time in arbitration. So they concluded, guess what? You can do better in arbitration than courts. I know because I spoke to the authors, they were astounded by that. They had not expected that. They found that the median damages in court was $95,000 compared to $100,000 in arbitration. The median award of attorney's fees was $69,000 in court versus $76,000 in arbitration. The biggest flaw with this study is it's Southern District of New York. It's not a representative court. It's a small sample. But others have found similar results. And in an empirical database that I have created, I have had similar findings. So I'm showing you where my research was as of 2008. I had 426 federal and state court rulings in employment disputes running from 1975 through 2007. Federal district courts confirm at a very high rate. And it's not surprising. When you look at how narrow the grounds are, again, for a review, these courts are confirming 93% of arbitrator awards. But this is what hooked my attention. This was a statistically significant difference here. And it begs the question, what is so different about the state court? The answer could be, yes, sir? Anybody? They're elected. Is there something about the election that does this? So that gets really to the heart of why we're here today. Again, this is a little slower. So this is going to be hard to read at a distance, but this is the model that I'm positing for employer avoidance of liability. It goes like this. Before the dispute, when the relationship forms, the employer requires the employee to waive her right to sue. That brings us down here. Now the employer specifies the forum, the rules, all of that. It's the employer's court, the employer's process. An arbitration occurs, and now I take account of the fact that empirically we're understanding that arbitrators are more fair-minded and buck the system that was set up for them, if you will. And they rule, and they provide a remedy that the employer refuses to accept. Now that leads to an interesting arrow that you can't see. The employer challenges the award by going to court and either using the 4 statutory standards, or there are common law standards. These are judge-made standards for reviewing an award. Think about this for just a second. It's a curious phenomenon. Don't go to court, employee. But now I want to go to court. It's heads I win, tails you lose. And then the next part of this model is asking the question, is this strategic model so well developed to the point where employers are electing judges with the idea of having judges vacate the awards that are adverse to the employer? That may sound implausible unless and until you see how much money is involved in some of these awards. Now, I have a small sample, and it is not a representative sample. I am sure I'm looking at the more extreme cases, are the cases that are litigated and reported. Nonetheless, these are some of the high dollar value of employment arbitration awards in my study. $38 million for one employee. $26 million for another, $10 million, and it goes on down. But when you look at those statistics, you can begin to imagine that perhaps some employers would invest in a campaign, knowing that, and I want to just make clear, in these arbitration agreements, the employer can specify the particular court to review the award. I can write in my employment agreement with you that you will arbitrate your dispute, and if either one of us challenges the award, it will be heard by the fill-in-the-blank court with the fill-in-the-blank address.